Before understanding how to give a reply to legal notice, it is necessary to understand what do courts love. Everybody loves something, but courts also love something, and that is evidence. And courts means judges, advocates, and court staff. Everybody loves evidence, evidence, and evidence. And remember, if there is no evidence, there is no justice. Courts are not emotional. Courts are scientific. Court wants proof, examination, cross-examination. What are these words? These words are scientific words. They are not emotional words. So court want facts with evidence. Not only a fact, but the evidence supporting those facts. If somebody is simply creating a fiction, now the context of fiction in a science fiction movie is different. In a court fiction, it is different. In courts, fiction means emotion, for which there is no evidence. Court will simply throw it outside as evidenceless fact. A fact without evidence is called fiction in the context of the court. Now, whenever you receive a legal notice, there could be facts, there could be fiction. It could be a percentage, 90% facts, 10% fiction, 10% facts, 90% fiction. So imagine a legal notice is received by you, which has 90% facts. Now there are two options here. 90% facts has strong evidence, based on strong evidence or weak evidence. Now, what is a strong evidence? The best example for the strong evidence is a bank loan. If you have ever had an experience of taking a bank loan, you'll understand what I am saying. Banks take 100 signatures for giving a single loan. Maximum of 100 signatures. For a normal personal loan, you have to sign 100 times. And rarely you read those documents. And the sum and substance of all those documents is that you can never escape even in the Supreme Court also for taking a bank loan. You have to pay. So therefore, the evidence of the bank is very strong. Now, you must respond to that legal notice. How you will respond? Simply deny. Deny that you had taken a loan from the bank. Now, you'll be surprised to hear this. How could you deny? But court loves denial. Because if you deny, there is something before the bank to prove. If you accept, where is the case? So denial is not an offense. You must deny. That is your right. Somebody files a case against you, you must deny. Even though it is true, even though it is fact, even though the evidence is strong, you must deny. Because it is your right, and court loves if you deny. Remember this. Simple denial is sufficient. Simply deny every fact that is alleged by a bank. That is a right in the Civil Procedure Code. That itself is sufficient. If there is strong evidence, if the legal notice constitute 90% facts, then give a reply to the legal notice. Consult some advocate, tell him, send a legal notice, reply legal notice, denying each fact. That itself is sufficient to prepare a legal notice. Give him fee, he will send. Now what happens if there is a weak evidence? Though there are 90% facts, but the weak evidence, what is a weak or a difficult evidence? Like SMS messages, call recordings. These are weak and difficult to prove evidences. For example, you give a loan to somebody by cash or take a loan by cash. Now there is no evidence except SMS messages or call recordings or WhatsApp messages. Now how difficult it is to prove that case? I will tell. If you want to rely on the call recording, you have to call the creator of the app who created the call recording app to the court. You have to call the representatives of your service provider, if it is a Jio or Airtel, you have to call them to the court. You have to call the manufacturer of your phone to the court. If you are using a Samsung phone, you should call somebody from Samsung to prove that call recording. Somebody from Airtel or Jio or BSNL or Vodafone to prove that they are providing the service to you, cellular service to you, and the app creator. So it is almost impossible to call all of them to prove your case. So therefore the evidence is weak, or I would put it in another way, it is difficult to prove. At that point of time, if you had taken by way of a cash or given by way of a cash, then ignore. There is no need to reply to that legal notice. There is no need to even deny, because denial itself gives some weightage to the case, if at all he files the case after receiving your reply legal notice. Therefore, you have to ignore if the evidence is weak, but there are 90% facts. Now the second option, if the legal notice constitute fiction, I already explained what is fiction in the context of the court. Simply ignore that legal notice. There is no need to reply to that legal notice. It is not at all mandatory to reply to a legal notice until and unless law speaks something about reply to the legal notice. Generally, law is quoted in the legal notice. Violation of law is quoted in the legal notice. Go and refer that law. If you Google, you will find out. Then only you must reply. Most of the cases, 99% of the cases, doesn't make it compulsory for you to reply to a legal notice. Okay. Thank you. Thanks for watching. Hope you liked my video. If you like, kindly subscribe and share.